Hi, this is Tatiana Moroz, and you're listening to Journalistic Revolution.
I'm Robert Wasmund, and welcome back to the Journalistic Revolution. In this segment of the show, we're going to go over the interview with defense attorney Adam Sudbury about Mark Schmitter's case. Remember, Mark was sentenced to 141 days for contempt of court. What was his contempt of court? Exercising the First Amendment and passing out jury rights on public land. First, we're going to start off with him making a statement about an update on Mark legally at this moment in time.
Right now, Mark's conviction has been upheld by the 5th District. We are seeking review of that opinion at the Florida Supreme Court, and we have asked the state courts to release him pending further review at the Florida Supreme Court, and then the next stop after that would be the U.S. Supreme Court. Today, that request was denied by the 5th District. We get to ask the Florida Supreme Court to review that, and if they deny it, that opens the door for us to pursue a federal habeas corpus action in the Middle District of Florida. And I think that is really our best shot of having Mark released pending further appeal. And so that's where we're at right now as far as the procedural posture of the case.
Now, this next part, I definitely wanted to include because he actually shows the free speech zone in the clip. So here's that clip.
If you just come over here real quick, and if you look at this box over here on the ground, you'll see kind of like it's now very much faded, a faint outline of a box.
Right.
There was an administrative order that essentially prohibited any quote-unquote First Amendment activities from being done, and that's literally the order said, First Amendment activities, from happening outside of that box. So what we're doing here now, me answering your questions, we would be in violation of that order because we're standing outside of that box. However, wisely, we believe the 5th District Court of Appeal found that that was too broad, that you couldn't do this, and so they invalidated that order. And on that basis, part of our appeal was granted.
Now, I've noticed on Facebook and also on our YouTube channel, people have been asking about Section 1983, and so they actually covered that in the interview, and here is that.
Now, Section 1983 United States Code creates a civil cause of action for someone that's been deprived of their constitutional rights under color of law by a state actor under color of law. And except for a specific, what's called a privilege, that would apply here. However, there is a defense to a Section 1983 action for judicial immunity and prosecutorial immunity, and the litigation of privilege applies. So basically anything a judge does that's part of his judicial functions is pretty much absolutely protected, and this is well settled law under, you know, the U.S. courts have ruled. I believe it's pretty much a frivolous pursuit to try to bring a cause of action for damages, as far as monetary relief. What we're doing in federal court is we have filed, number one, a declaratory judgment action challenging, well, we were challenging both orders, but we won on appeal for one of them, so now there's one remaining order that we're continuing to challenge to vindicate his right, not to seek any monetary damages, but we believe that Mark Schmitter, and in fact all the FIJA activists that do this, have the absolute right to engage in this type of speech, and that there is no basis for a judge or a state legislature, for that matter, to infringe on that First Amendment right to make their point of view known.
Finally, last part, he talks about why Mark wasn't given a jury trial, and who FIJA is, and what their cause is, and why it's so important. We'll be going over more of this in our regular show when Matthew Dalton will be here as well. So, and here's the final clip.
Why wasn't Mark given a jury trial? He was sentenced to, what, 6 months, 5 months in jail, all at the hands of a judge. I thought it was a constitutional right that any crime over a $20 value, you were entitled to a jury trial?
Well, that's actually a really good question, and the answer to that is that there's a very narrow exception that's recognized by the U.S. Supreme Court and by many courts around the country, and that is the contempt power of the court. So basically, what that means is that if you intentionally violate a court order, that judge that wrote the order can act as the trier of fact for your trial on contempt, and also can sentence you up to 6 months in jail. Truly, we appreciate everyone's support. This cause is a very worthy cause. Not only is free speech at issue, but FEJA's mission, jury nullification, although I don't like to call it that, but really the right of a jury to judge both the law under which someone is charged and the facts under which someone is charged is so incredibly important to our system of justice, because the jury is the last obstacle to physically putting hands on someone and depriving them of their liberty. And if you can't get the facts past a jury, you should, and if a law is immoral and unjust, and believe me, there's lots of those laws out there, a jury should be able to say, we're not going to enforce this. Because when the state legislatures and when the U.S. Congress comes to deprive you of your God-given constitutional rights, it's that 6-person or 12-person jury that is the final arbiter of those rights, and they should be able to judge the law as well as the facts. And that's what FEJA is all about. I personally believe in FEJA's mission. Mark believes in FEJA's mission, and of course the issue of freedom of expression is a critical component to all of this.
Thank you for making that point.
Make sure you stay tuned in for the next episode, The Journalistic Revolution, news you need to be involved in.